to talk a little bit about garnishment. What happens if you've already got a judgment that's been entered against you, and now either that judgment creditor is coming after you, or you're assuming that he's about to come after you to try to, for instance, garnish your wages. There are two fundamentally different circumstances that can exist. One is if the judgment debtor is married, but the judgment is only against one of the two people. And the other circumstance is where the judgment is against both husband and wife, or if the judgment debtor is a single person. So right now I'm going to talk about the first scenario, where the judgment debtor is married, but the judgment is only against that one person. Their spouse was not named in the lawsuit, and the judgment is not against them. First thing I want to say is that all kinds of judgments in Florida, the process from the standpoint of the garnishor, the judgment creditor, it can be quite complex, and we find it's very common that, quite frankly, they just screw it up. And we can get the whole thing thrown out because they missed one of the procedural requirements. And the law is very clear that that law is strictly interpreted, and that all of the requirements must be met in order to have a valid garnishment. Now, typically the first thing the judgment creditor comes after are your wages, where you work. That garnishment is served on your employer, and it's what we call a continuing writ of garnishment. In other words, once they serve it, it continues to apply to every paycheck you get after that until the judgment has been satisfied. First thing to know, if your gross earnings, your income before any deductions, is less than $750, your wages cannot be garnished. If you make more than $750 per week, then your wages can be garnished. There are exemptions. If you're married, then the number one exemption is I'm head of household. Head of household is a real simple definition. Who makes the most money? If you make more money than your spouse, you're head of household, and vice versa. So if someone's trying to garnish your wages and you make the most amount of money in the family, then you're head of household. Now, head of household, we would normally think, well, that's, my wife, my kids, my husband, my kids. But head of household means that you have dependents living in the house with you. They don't necessarily need to be your spouse or your children. It could be your parents, your brother, your sister. Now, the next scenario for a married person who has a judgment against them is the person who says, well, I don't get a paycheck. I'm self-employed. I own my own company. What's my situation? Well, the law in Florida gets real quirky there, in that the courts have interpreted the law such that this wages exemption for head of household does not apply to a person who is self-employed and who, according to the law, basically controls the timing of their own income. I personally think it's unfair. I think it's unjustifiably discriminatory against self-employed persons, but as far as the law goes, that's the way it is. Now, there's a silver lining to that, in that if what a self-employed person earns doesn't come under this category of wages, then the courts have also said, well, Mr. Judgment Creditor, you can't get a continuing writ of garnishment, because continuing writ of garnishment only applies to wages. So the judgment creditor in that situation has to be repeatedly trying to garnish a bank account to try to get it at a time when some earnings have come into that account. It's very hit or miss. As I said in the beginning, the garnishment procedure can be complicated, and it's not cheap. So there is that silver lining for the self-employed person. You want to have your money come into the account very sporadically, and you want to get it out of there, out of that business account, as soon as you can. And what do you want to do with the money? Well, regardless of whether you're a wage earner or a self-employed business person, get the money into an account with your spouse, because there's very good case law in Florida. One of the cases came out of the bankruptcy court right here in the Middle District of Florida, where they said that for a wage earner who's married to bring home their earnings or their self-employed earnings and put those into a joint account with their spouse for the purposes of operating and maintaining their household is not a fraudulent conveyance. And you now have a new exemption which applies, and that is property that you and your spouse own together as tenants by the entireties is also exempt from garnishment. And if you've set up the bank account properly, you want to make sure it's set up as tenants by the entireties, then your earnings that go into that account become exempt. Now, one of the things I always tell people about garnishment is, the good news is you're going to win. This account is not garnishable for one of those many reasons that I just talked about. The bad news is it's going to cost you $1,500 to win. So don't be complacent and thinking, well, I've got this exemption and I've got that exemption, and if they try to garnish the account, I'll win. Yes, you will win, but you're going to spend $1,500 in order to win. So you basically win, but you also lose $1,500. Now, I'm also going to talk about, in a separate video, what's the situation which most lawyers think are the mission impossible, and that is when you have a single debtor or husband and wife who are both liable on the judgment. Maybe they've both signed the guarantee on the note. And because obviously you don't have the tenancy by the entireties exemption, there are a lot of exemptions you don't have because they can go after what either one of you own. So I'm going to do another video, and we're going to talk about what